There are two stories now that I'm following and following thoroughly. One of which is Tyler Robinson's trial, which is not yet at the trial stage. It's at the preliminary stage where Tyler Robinson's lawyers doing what lawyers do, which is what makes you hate lawyers, because it's a game. It's a game that's played with tools, with tricks, with trickery within the bounds of the law. And a defense attorney's not objective, but their job, and not just doing their job like just following orders. Their job is to make the prosecution prove their case beyond a reasonable doubt in the context of criminal law. Their job is to basically make the prosecution work as hard as humanly possible to raise all reasonable doubt, to raise all procedural objections within the bounds of the law, because everyone is innocent until proven guilty, even if you think they're guilty as hell. And if they don't do that, if they don't vigorously pursue all avenues of defense for and on behalf of their client, they are failing in their duties to their client. And yes, I said duties. And I've been watching some of the, not even highlights, I've been going through the hearing that's been going on right now, because the defense attorneys, Tyler Robinson's attorneys, are making a procedural mountain out of an insignificant molehill as far as I'm concerned, which is to disqualify the prosecution because allegedly the daughter of one of the prosecutors was at the event and heard the shot ring out, and therefore somehow her father would not be able to prosecute this case in earnest. And I don't know if that's the right word, actually, if that's the right use of the word in earnest, but they had a big hearing yesterday, and I pulled a couple of highlights. But if you didn't hear the latest of the news, this is ongoing now. It was, it's going on for hours on end. Lawyers for Charlie Kirk's alleged killer ask to have prosecutors thrown off the case. On the one hand, I say, like, okay, fine, swap out the prosecutors. Who gives a sweet bugger all? On the other hand, flip side, who cares who prosecutes this? I mean, you're going to say someone who has a family member that was tangentially related or somehow a witness is the argument. What difference does that make? But alas, the defense attorneys are doing what defense attorneys do, which is to make the prosecution as hard as possible. And I will argue, doing some things that are, I won't say unethical, because that's not the right word. I might say untoward, or I might say a little bit shady. And what that might be is tainting a jury pool by putting out into the public, or at least putting out what they know will get out to the public, information which is either unverified at best or unproven, to put it most charitably, or false at worst. And we'll get to that in a second once I read through a little bit of this article, which is the latest of what's going on in this case. Pretrial hearing for Tyler Robinson, the accused killer of Charlie Kirk. The defense again argued the prosecution should be thrown off the case. Robinson's attorneys want the entire Utah County Attorney's Office disqualified because one of the prosecutors has an 18-year-old daughter who was present at the rally at Utah Valley University in Orem, where Kirk was shot. And so you just ask yourself, what difference does that make? You want the entire prosecution thrown off the case. Bring in another prosecution. Who cares? It'll be from another, it'll be another set of prosecutors. Who cares? But defense doing what defense does, they're going to make any argument they can to complicate this for the prosecution. Utah County Chief Deputy Prosecutor Chad Grunander testified that he received texts from his daughter right after the killing saying someone had been shot at the school and that she was okay. Defense attorneys previously said in court documents that the personal relationship is a conflict of interest that, quote, raises serious concerns about past and future prosecutorial decision-making in this case. That argument, I've mentioned this before, but that argument doesn't make sense to the extent that they're seeking a conviction. If it turned out, hypothetically, that there was some other type of relationship that might question whether or not the prosecutors would genuinely and sincerely prosecute this case, then you can imagine it. All right, so his daughter was there. He's going to be a very vengeful prosecutor. Maybe he's going to break some rules because he's angry that his daughter had to witness this, and so he's going to do untoward things to seek a conviction of Charlie Kirk's killer. Maybe. Alleged killer, I should say. They also argue that the, quote, rush to seek the death penalty against the 22-year-old is evidence of strong emotional reactions by the prosecution, or a perfectly normal reaction to what the alleged crime is. Grunender's daughter also testified during the hearing, but that portion was closed to the public to protect her identity. According to an affidavit submitted by prosecutors, she did not see the shooting. Quote, while the second person in line was speaking with Charlie, I was looking around in the crowd when I heard a loud sound like a pop. Someone yelled, he's been shot, Grunender's daughter said in the affidavit. She later texted the family, said Charlie got shot. In the aftermath of the shooting, she did not miss classes or other activities and reported no lasting trauma aside from being scared at the time. Grunender said he decided early to disclose this information about his daughter because it could be portrayed as a potential conflict of interest. Don't mistake my disclosure to be a concession that we believe there is merit to this alleged conflict of interest. Okay. Earlier, Utah attorney Jeff Gray took the stand defending his decision to seek the death penalty. Gray testified he was not influenced by Grunender and decided to pursue an aggravated murder. I mean, it's wild, but then you think, what are they doing right now, this defense, other than putting into the general public field that, for any prospective juror, that the decision to seek the death penalty was somehow extraordinary under this set of circumstances? I mean, I think it's something that every rational person on earth would be clamoring for under these circumstances. But alas, all of this gets public to reach a potential jury pool, and they are going to hear these arguments that even seeking the death penalty was exceptionally punitive for a first-degree aggravated murder. Okay. Grunender said he doesn't believe Gray's decision to seek the death penalty was influenced by his daughter's presence on the scene. Of course. Wednesday's proceedings continued at a hearing that began January 16th. Okay, we heard all that part. Judge Tony Graff denied a request to refer the case to the Utah Attorney General's office and said he will issue a ruling on that. So I'll break this out. That's the gist of the article. They're asking for two things. Disqualification of the prosecution's entire office. And what they also argued was that the prosecutor themselves can't argue this case because they have a conflict of interest insofar as they're being sought to be kicked off the file, and so it should be returned to the Attorney General's office to make the decision. And the judge said, no, we're not going to do that. They can make the decision here. They can argue it on their own, and we don't need to take that exceptional case to send it back to the Attorney General's office because they're so conflicted they can't even defend their own presence in this case. Now, I posted that highlight, and I want to get that one because it's good to hear the judge come to a relatively obvious decision. And it's right here. Let me bring this one up. But then we're going to get into what I think is the dirty play here. So the dirty play that is par for the course when it comes to attorneys and why they have inherited and earned the reputation that I do incidentally believe they so deserve.
So before this court's defendants renewed request to refer the pending motion to disqualify to the office of the Utah Attorney General.
So they wanted to return it to the office of the Utah Attorney General on the basis that the prosecution could not even defend itself from the motion to disqualify because they'd be conflicted. And the judge has this to say.
In support of that request, the defendant relies upon Utah Code Section 17-18A-304, which provides that the Attorney General shall assist a county prosecutor only if the court finds that the prosecutor is unable to satisfactorily and adequately perform the duties of prosecution and recommends that the prosecutor seek additional legal assistance.
I don't want anyone giving me flack for the audio. This was court audio for the judge in particular, and I think they resolved it partway through.
The defendant argues that where there exists a non-frivolous basis, factual basis, suggesting a potential conflict of interest, the court should make such a finding and recommend assistance from the Attorney General. The court has carefully considered that argument and reviewed the briefings. However, the statute does not adopt the standard proposed by the defendant, nor does such a standard appear in existing case law or court rules. The statute requires specific findings regarding a prosecutor's inability to satisfactorily and adequately perform prosecutorial duties before referral is appropriate. At this stage of the proceeding, the court is not persuaded by those statutory conditions have been met. Based on the record presently before the court, there is no indication that the Utah County Attorney's Office lacks the resources, knowledge, or ability to litigate the motion to disqualify on behalf of the state.
So you imagine, I'll stop it there. That's about as much as we need. The judge says, no, they can litigate it. So we'll do that a little bit later. The defense is asking for the disqualification, but also that the prosecutor's office can't even defend against their motion for disqualification because conflict. Judge says, no, they can. We'll do that later. Irritating, wasting a day or two, and arguably putting out information into the public sphere, which I presume they would presume is going to be beneficial for sowing a seed of doubt. But when you want to get to what I think is sort of the very judicially dirty method of doing that, this is Tyler Robinson's defense attorney right here, or at least one of them. This is from Jack Posobiec. This moment from Tyler Robinson's lawyer, Kathy Nestor, is crazy. She asks him about DNA collected, isn't specific what she's talking about, mocks the investigator, then walks away and admits she doesn't actually have anything to add. Take that description with a grain of salt if you so choose, but let's listen to this and I'll tell you exactly what I think is going on here, and I think it's dirty.
And you mentioned, I know I have 2 minutes. I'm going to talk very fast. I know she's about to kill me. You mentioned the...
First of all, probably not the best expression to be using under the circumstances. You only have 2 minutes and you just wasted 10 seconds complaining about the fact that you only have 2 minutes. All right, Viva, stop being nitpicky here.
DNA evidence. You're certainly not a DNA expert. Is that correct?
I'm not, no.
And are you aware that the DNA evidence that was seized from the scene consisted of a mixture of at least 5 different individuals?
I'm not a DNA expert, so...
So you know enough to say what helps him, but you're not going to answer whether or not there were 5 individuals mixed into that DNA?
I'm not aware of that, no.
Okay. And you're certainly not qualified to interpret complex DNA mixtures, are you?
No, I'm not.
Okay. Court's indulgence for just one moment, Your Honor.
I think you've had a little bit too much indulgence there, if I dare say so myself.
6 minutes.
Ms. Nestor, is there, I know I gave you that 6 minutes. Is there any other questions that you feel you need to ask?
Thank you for asking, but I think I'm done.
Thank you for asking, but I think I'm done. I can't stand the faux politeness of the practice of law. It was the most frustrating thing for me to deal with for 13 freaking years. Yes, Your Honor. Yes, you have to be very polite. You have to wait for the judge to be finished. You have to speak slowly. Can we just get back to the critical element of what just went down in there? And she got the indulgence of the court, and I would dare say it's not to armchair, whatever it is, quarterback or backseat drive or passenger seat drive. Why the hell wasn't there an objection? I don't want to listen to let's listen to the first part again.
And you mentioned, I know I have 2 minutes. I'm going to talk very fast. I know she's about to kill me. You mentioned the DNA evidence. You're certainly not a DNA expert. Is that correct?
I'm not, no.
And are you aware that the DNA evidence that was seized from the scene consisted of a mixture of at least 5 different individuals?
Are you aware of the DNA evidence collected from the scene contained a mixture of at least 5 individuals? Do you understand what's going on there right now? Like, if you're not, I won't say even legally trained, but if you're not picking up on not semantics, but trickery, are you not aware of a fact? That presupposes it's a fact. I'm sitting here saying, like, I've been following this case mildly closely. Was it the case that DNA from the scene consisted of a mixture of 5 individuals? She asks the guy a question predicated on a fact that is, at best, as of yet unproven, and at worst, totally false. But it's out there. And now, because he answers the question, because there was no objection, Your Honor, assumes facts not in evidence. Unless it's in evidence, but I don't think it's in evidence.
I'm not a DNA expert, so...
So you're not an expert, right? So you couldn't answer a question based on a fact that is unproven or outright false. And I'm going to continue asking you the question. There's no objection, and he'll answer the question. And right now, you have a sound clip reaching the population at large that seems to assume as true a fact, put it in quotes, which is unproven at best.
So you know enough to say what helps him, but you're not going to answer whether or not there were 5 individuals mixed into that DNA.
I'm not.
Her question was not, were there 5 individuals mixed into that DNA? Her question was, are you not aware of the fact that there was DNA with 5 individuals mixed into it? It goes from an assertion of fact to then a question later on. Nobody's objecting, and he's entertaining these unproven or outright false factual premises.
Not aware of that, no.
Okay. And you're certainly not qualified to interpret complex DNA mixtures, are you?
No, I'm not.
Okay.
So now we're going to presume, I guess, that what's going to come up in the defense is that the DNA, whatever DNA they found there, is going to be the mixture of 5 different people. And that they're going to say, well, based on that, this is coming from the defense. And I presume, my goodness, I hope that's what their expert is going to testify to. Because there's a mixture of 5 persons' DNA in there, you can't definitively assert that it was Tyler Robinson who was on that rooftop. But I want to know if I'm being overly nitpicky. I was accused of objecting too much as a lawyer, because I was also accused of making it impossible for opposing counsel to ask a question, because I would very much nitpick and say, I'm sorry, your question presupposes a fact that has not yet been proven. I would pick up on it. I would get irritated by it. I would object. And then, the typical response is, let them respond and a judge will deal with the veracity. In Quebec, we don't have jury trials, at least not for civil matters. And now the question is going to be whether or not that's a true fact, a false fact, a lie that has now been put out there literally to poison the well of anybody who's going to be a prospective juror there. So they're still talking about it. And we'll see where it goes. I'm going to be following this now because it's above and beyond being disgusting, devastating to families, to a political movement. It will be fascinating to see this trial play out in real time. It had better be public so that everybody can see this in real time, so that the aggregate knowledge of the internet can piece together the truth or parse out the lies. But that's what happened in Tyler Robinson latest.